Tully Rinckey, PLLC thanks the Federally Employed Women Executive Committee for allowing the firm to present this free webinar to federally employed women members. The firm supports federally employed women's goals and objectives, and we are pleased to be of service to you. Through our partnership, federally employed women members are entitled to one free half-hour phone consult per year regarding federal employment, security clearance, or military matters. Members pursuing claims receive a 10% discount on legal fees. Tully Rinckey PLLC will also donate 5% of any legal fees into a federally employed women legal defense fund. Call 202-803-7330 or email us at info@fedattorney.com to learn more about our partnership with federally employed women and schedule your free consultation. Again, that number is 202-803-7330, or you can email us at info@fedattorney.com. Tully Rinckey PLLC partner and consult attorney Stephen L. Herrick, Esquire, has over 30 years of experience in all facets of litigation. He provides counsel to clients across a broad spectrum of employment-related matters. Steve holds a wealth of experience practicing before federal, state, and District of Columbia courts, the Merit Systems Protection Board, and the Equal Employment Opportunity Commission. He also has deep experience representing clients in arbitration, mediation, and agency proceedings. Tully Rinckey PLLC is one of the nation's largest federal sector labor and employment and military law firms. We're a full-service firm for federal and government employees with legal issues. Our attorneys together have about 130 years of experience practicing federal employment law. They are key components of a team whose targeted, aggressive legal approach has secured positive results for clients in virtually every aspect of federal employment and labor law. Don't leave the future of your federal career to chance. Call 202-803-7330 or email us at info@fedattorney.com to schedule your free consultation with a member of our team. Now, I'll turn the floor over to Stephen L. Herrick, Esquire.
First, I'd like to thank the federally employed women for allowing us the opportunity to present this webinar, which is entitled Protections under the Rehabilitation Act /ADA. And ADA, of course, stands for Americans with Disabilities Act. To start with, I want to clarify an issue of some confusion. Sometimes I get calls from federal employees or applicants saying that they wish to present a claim under the Americans with Disabilities Act. In fact, the statute that applies to federal applicants and employees is the Rehabilitation Act. And the Rehabilitation Act prohibits discrimination against a federal employee solely by reason of his or her disability. The Rehabilitation Act further provides that no otherwise qualified individual with a disability may be subjected to discrimination by any federal agency solely by reason of her or his disability. Now, the Rehabilitation Act standards are the same as the standards under the Americans with Disabilities Act. The standards used to determine whether the Rehabilitation Act has been violated in a complaint alleging employment discrimination are the same standards applied under provisions of the Americans with Disabilities Act. So although the statutes are different, the Rehabilitation Act providing remedies for federal applicants and employees, and the Americans with Disabilities Act providing remedies for private sector employees, this is what we in the legal business call a distinction without a difference. Basically, the standards are the same. Now, under the standard established by the Americans with Disabilities Act, no covered entity shall discriminate against a qualified individual with a disability because of the disability of such individual in regard to job application procedures or the hiring, advancement, or discharge of employees or employee compensation, job training, or any other terms and conditions and privileges of employment. Now, in this webinar, we're going to talk about two particular periods of time. One is the pre-offer period, and that would be when an application has been made by an applicant for federal employment. The other period that we're going to talk about is post-offer but pre-employment. In other words, the application has been accepted and the offer of employment has been extended, but the employment has not yet started. So let's start with pre-offer questions, inquiries, and examinations under the Rehabilitation Act and ADA. Now, there is important distinctions that you have to keep in mind between the pre-offer stage, which is the application, and the post-offer stage, which is the application has been accepted, the offer extended, but employment has not yet started. So let me start by discussing the pre-offer questions. During the application state or pre-offer state, the agency may not conduct medical examinations, make inquiries of the job applicant to determine if the applicant is an individual with a disability, or make inquiries of the job applicant to determine the nature or severity of any disability that the applicant may have. Now, in the post-offer stage, prior to the actual starting of employment, a covered entity may require a medical examination after an offer of employment has been made to a job applicant and prior to the commencement of the employment duties of such applicant, and may condition an offer of employment on the results of such examination. So a very important distinction between pre-offer, in which a medical examination cannot be made, and post-offer, but pre-employment, in which a medical examination can be required. Now, this raises the question of what is a medical exam? And the Equal Employment Opportunity Commission, the EEOC, has defined a medical examination as a procedure or test that seeks information about an individual's physical or mental impairments or health. Now, there are several factors that are used to determine whether a pre-employment examination is a medical examination, which, as I've noted, is prohibited in the offer stage, pre-offer stage, but permitted in the post-offer pre-employment stage. And some of the important factors are, is the test administered by a healthcare professional? Obviously, if it is, that suggests that the test is, in fact, a medical examination. Other factors tending to indicate a medical examination are whether the results are interpreted by a healthcare professional, whether the test is designed to reveal a health impairment, is the test a measurement of physiological responses to performing a task rather than the performance itself. And I'll get into a specific example of that a little later in the webinar. Other factors, the location of the test, is it in a medical setting, such as a healthcare professional's office? And lastly, is medical equipment used, which obviously, if it is used, suggests that the test is a medical examination. What tests are permissible before the agency gives an offer of employment? The agency cannot use a standard that screens out applicants with disabilities unless the standard is job-related and consistent with business necessity. And now there is an important distinction, although it may seem to be a narrow one, between a medical examination and a physical fitness test. A physical fitness test is defined as a test in which an applicant's performance of physical tests, such as running or lifting, are performed. This, under applicable EEOC regulations, is not a medical examination. And as I indicated before, I'm going to give you an example of this distinction. A test where an applicant is required to lift a 30-pound box and carry it 20 feet. If the evaluation is limited to whether the job applicant can, in fact, carry the box, then that is not a medical examination. However, if the test, for example, measures blood pressure or heart rate, then the test would be a medical examination, because in that case, the applicant's physiological response, as opposed to the applicant's ability to lift the box, is what is being tested. So that's a key distinction, because the physical test is permitted, but the medical examination may not be. still in the pre-offer stage now. What other pre-employment inquiries can be made? We're now on slide 10. The agency may make pre-employment inquiries into the ability of an applicant to perform job-related functions. The agency may also ask the applicant to describe or demonstrate how, either with or without reasonable accommodation, the applicant would be able to perform the functions required by the job. Notwithstanding, the agency's inquiries must be limited to determining whether the applicant can perform the essential functions of the job. There is an additional caveat with respect to that. The agency can only ask the applicant to describe how they would perform the job functions as long as all applicants in the job category are asked to do that. In other words, not just someone who is disabled or who is perceived to be disabled is asked those questions, but all applicants in the job category are asked those questions. Only then is that question permissible. Examples of what the agency cannot request of an applicant. We're on slide 12 now. And the first one of these is, the first question here is, may an employer give alcohol tests to applicants? And the answer to that is no. Tests to determine whether and or how much alcohol an individual has consumed are medical and therefore not permitted. Next question, may an employer ask applicants about their workers' compensation history? And I think the obvious answer to that is no. An employer may not ask an applicant about job-related injuries or workers' compensation history, as these questions relate directly to the severity of an applicant's impairments. Therefore, these questions are likely to elicit information about a disability and therefore are precluded at the pre-offer stage. Conversely, on slide 13, we have examples of permissible pre-offer agency inquiries. And the first one is, may an employer ask whether an applicant can perform the job? And the answer to that question is yes. An employer may ask whether the applicant can perform any or all job functions, including whether applicants can perform job functions either with or without reasonable accommodation. Next question, may an employer give applicants tests to determine illegal use of controlled substances? And the answer here again is yes. The Americans with Disabilities Act specifically states that tests to determine the current illegal use of controlled substances are not considered medical examinations. Now, you may be wondering why a test to determine alcohol use is not permitted, but a test to determine controlled substance use is permitted. Unfortunately, I cannot answer that question. That is just the philosophy underlying the Americans with Disabilities Act. Now, an example of the type of inquiry that has been permitted, the type of pre-offer inquiry that has been permitted is shown on slide 14, and this involves a case involving an applicant for a job with the Postal Service. And in that case, Day versus Postmaster General, it was held that an agency may make a pre-employment inquiry into whether an applicant can perform any or all job functions. And in that case, it was found that the position of postal clerk that the applicant was applying for involved standing, stretching, reaching, and handling heavy sacks of mail. Since those were the requirements of the job, it was permissible in the pre-offer stage for the interviewer to ask questions as to whether or not the applicant could perform those tasks. The administrative judge ruled that there was nothing wrong with those questions, and therefore the complainant, the applicant who complained that the asking of those questions was a violation of the Rehabilitation Act, that complainant lost, with the administrative judge finding that the complainant had failed to establish that the mere asking of those questions constituted a violation of the Rehabilitation Act, because those questions pertain to job functions of the position of postal clerk. Now, moving on to the post-offer stage, and by that I mean, again, that an offer of employment has been made, but the employment has not yet started. Here, the rules are very different from those that apply in the pre-offer stage. After the agency has made an offer of employment, the agency, by federal statute, may require a medical examination and may condition an offer of employment on the results of that examination. Very key distinction between pre-offer and post-offer. After an applicant is given a conditional job offer, but before the work starts, an employer may also make disability-related inquiries and, as noted, conduct medical examinations, regardless of whether they are related to the job, as long as it does so for all entering employees in the same job category. Again, as discussed before, these inquiries are appropriate as long as they are not limited to being asked of applicants who are disabled or who are perceived to be disabled. If they are asked of all applicants, regardless of disability, those questions are proper. At the post-offer pre-employment stage, the agency can also ask the applicant about prior sick leave usage, workers' compensation history, which is noted was not permitted in the pre-offer stage, may also ask about prior sick leave usage, illnesses, diseases, impairments, and general physical and mental health. So as you can see, once the offer has been made, but before the employment has started, the rules are very different, and the agency has a great deal more of discretion in what kind of information it can require the applicant to provide. Moving on to slide 16, a couple of questions regarding what inquiries the agency may make in the post-offer stage. At that point, may an employer ask all individuals, not just individuals who are disabled or who are perceived to be disabled, whether they need reasonable accommodation to perform the job that they have been offered? And the answer is yes, that question may be asked. Then the question, once an agency has obtained medical information, basic medical information, and again, on a non-discriminatory basis, all individuals are asked, not just disabled applicants or those who are perceived to be disabled. May the agency then ask specific individuals for more medical information beyond the basic medical examination that has previously been performed? And the answer again is yes. If follow-up examinations or questions are medically related to the previously obtained medical information, those follow-up inquiries are permitted. Now, what happens if you, as a federal job applicant or someone who has received an offer but has not yet started employment, believes that there has been a violation of the Rehabilitation Act? What are you required to do? Well, there is a key requirement, and that is known as administrative exhaustion. And in other words, another term for administrative exhaustion is EEO claim. Before you are allowed to proceed further in the EEO process, you must exhaust what are known as your administrative remedies. And in this case, the commencement of the administrative remedy phase is the contacting of the agency's EEO counselor. Okay? All agencies have EEO counselors. Sometimes they are designated as such. Sometimes they have other names, such as Office of Civil Rights. But in any event, if you wish to file a complaint, you must determine who the appropriate person is, and you must contact that person. And you must contact that person within 45 days of the date of the alleged adverse action. Now, you may ask, what is an adverse action? Well, in the pre-employment stage, the pre-offer or pre-employment stage, an adverse action is either the denial of an application for employment or the withdrawal of an offer of employment after it has been made. That is the adverse action, and the law requires that in order for you to proceed, you must contact an EEO counselor within 45 days of when that action is taken. And that period is not waivable. It is a firm 45-day period. If you have a complaint, but you don't raise it with an EEO counselor within 45 days, your claim is time barred and it cannot be brought. Now, in certain situations, it may not be clear exactly when your cause of action or your claim has accrued. So to be cautious, you should contact an EEO counselor within 45 days, not of an adverse action, but of the date of the alleged unlawful inquiry, question, or examination. In other words, someone asks a prohibited question during the pre-offer interview or improperly requires a medical examination, you should contact the EEO counselor immediately and file that EEO complaint. If later on you are subjected to an adverse employment action such as denial of your application for employment or withdrawal of an application that has been made, you can amend your EEO complaint to assert that adverse action. But again, the 45 days is critical, so you must be certain that you contact the EEO counselor within that period of time. Now, once you have done that, there are certain standards that you must meet with respect to the allegations in the complaint. Simply alleging that the employer has discriminated against the applicant or employee because of the employee's disability is not sufficient. That is not considered administrative exhaustion in the pre-offer or post-offer / pre-employment stage. In other words, just arguing that you were required to take a medical examination improperly does not satisfy the administrative exhaustion requirement. You must specifically allege that it was an improper medical inquiry under the ADA or, more appropriately, in a federal situation, under the Rehabilitation Act. Likewise, even if you have suffered an adverse action, you must show damages from that action. Now, in an adverse action situation, if you were deprived of employment or had an offer of employment withdrawn, it is somewhat, easy to satisfy the damages requirement because obviously you were not going to be receiving salary or wages that you would have received had your application been approved and had you not been discriminated against on the basis of disability. In this situation, though, where no adverse action has been suffered, where you're simply alleging that an improper question was asked or an improper medical examination was required, you must show that you suffered damages. Damages must be based on something more than a mere violation. In other words, if you were required improperly to take a medical examination, that in and of itself does not establish a claim because there is no assertion of damages connected with that requirement. A claim based upon improper medical inquiry must be based on more than bare allegations of emotional or mental distress, mental anguish, stress, or inconvenience. In this kind of situation, it is highly recommended that if you suffer an improper medical inquiry and that it has caused you emotional distress or mental anguish, that you go to a medical professional and obtain medical documentation in support of that claim. Otherwise, you run the risk of having your claim being dismissed because you have not alleged damages. Now, you may have gotten the idea that the EEO process, the process that is required to be undertaken as a result of disability discrimination, is a complex one, and you would be correct. And that is why we recommend that anyone in this situation contact an experienced EEO attorney who can assist you with the process. And as you see on slide 20, there are a number of ways in which this can be done. The attorney can counsel you on recognizing and preserving your claim. Most importantly, negotiating with the agency, potentially to settle your dispute, ensuring that your claim is interposed timely so that it is not barred, and also importantly, level the playing field, because the agency will have attorneys on their side, and those attorneys are not shy about taking advantage of their knowledge of the process to the detriment of a complainant. So again, leveling the playing field, a very important reason why as soon as you believe that you have a potential claim under the Rehabilitation Act, that you contact an attorney. And lastly, if you are unfortunate enough to suffer one of these claims and need to file a complaint, we hope that you will reach out to us and ask us to assist you with our expertise in analyzing the strength of your case and the potential remedies that are available to you, and assisting you in getting the justice that you deserve under the circumstances. Again, thank you to federally employed women for allowing me to present this webinar, and I wish you the best of luck in your federal careers. Thank you.
Thank you for viewing this webinar led by Tully Rinckey PLLC's Stephen L. Herrick, Esquire. If you'd like to learn more about how to best defend your federal career, call 202-803-7330 or email info@fedattorney.com to schedule your free consultation with a member of our team. As a reminder, our experienced team of national security clearance attorneys regularly assists federal employees and contractors, as well as military personnel, in all stages of the security clearance process. They've helped hundreds retain their clearances. Our military law team is nationally recognized for its ability to win cases against tough odds. Our military lawyers have proven track records of changing the military law landscape through knowledge and tenacity in all matters faced by service members, including but not limited to courts-martial, discharge upgrades, and desertion. Don't leave the future of your federal career to chance. Call 202-803-7330 or email info@fedattorney.com to schedule your free consultation with a member of our team.